Alrighty. Welcome back. As people come in, we want to start on time to make sure that our next set of panelists get their full time. Our moderator will be Tonya Evans, professor of law from Penn State Dickinson Law and a 1998 Howard University School of Law alum. Professor Tonya, I will hand this over to you to talk to us and introduce us to your group. Mute.
All right, there we go.
There you go.
Welcome everyone, and thank you very much, Charlie, for handing it over to me. I want to definitely give a shout out to Latif and April and all of the folks who worked extremely hard to pull this together. Also fantastic to see Isabel and Alexis, and we are going to talk about the intersection of intellectual property, also the regulatory environment at the access of blockchain distributed technologies and cryptographically secured assets. My name is Professor Tonya Evans. I'm a full professor at Penn State Dickinson Law School. I also have a co-hire appointment at the Penn State Institute for Computational and Data Sciences, which is a long way to come for someone who is tech adjacent, but also someone who prepared to pivot not only my practice, but ultimately the profession and my own portfolio. So personally and professionally, this has been an interesting journey for me. I entered into the crypto space begrudgingly and certainly with a lot of, I think as lawyers, we are generally risk averse, and we make the big bucks for finding all of the points of risk and to mitigate or eradicate. But I've also found, as a matter of competence, the competence to practice law, when we think of the model rules in 1.1, and the comment 8 in particular talks about not just the competence, generally speaking, with respect to subject matter, but also technological competence. That began in 2012. And when I think of the 14 years that have passed since that earth-shattering comment, we've come a long way. The world will change more in the next 2 years than it did in the last 10. And so it is incredibly important for incredible lawyers like Isabel and also Alexis to help us navigate the intersection of our current expertise with what the future holds. And little fun fact, the future is now. And so with that, I'm going to pepper the conversation around. I also, in addition to teaching blockchain, cryptocurrency, and law, I also teach administrative law, information privacy law, and entertainment. So it's been really interesting to be in this space and see all of those disciplines being disintermediated, being disrupted, and finding not the considerable legal questions, but also the opportunities for those who are forward thinking. And so I look forward to this conversation. I will have our esteemed panelists introduce themselves, and then I'll just throw in some topics that we can all weigh in on. Their particular expertise is where we'll focus our time and attention as well. So we'll have some certainly with intellectual property, but then to talk more generally about the regulatory environment and where we are now and where we might be in the future. So with that, Alexis, will you start us off with introductions?
Hi, everyone. Thank you for joining. I am a patent prosecutor at Schwegman, Lundberg, and Woessner, SLW, and we are all over the country, but I am in San Francisco. I started off as I knew I wanted to be a patent prosecutor, so I started off as an engineer, doing software engineering, and went straight into patent prosecution, mostly in the infancy of cloud computing about that time. So for about 15 years, as you're talking about competency, my practice has gone from cloud computing, which at the time I thought was very specific, to now very specific. Blockchain, generative artificial intelligence, machine learning models are where I really focus and hone in. And I will be in the patent prosecution field forever. So my fintech knowledge is much more limited, and that'll be your and Isabel's section for today.
That sounds great, but I think you're a prime example of, as long as you remain nimble, you have your core competency, and then you are spotting the issues and the opportunities for clients and moving forward. And I think that is an excellent model for those who are hesitant. I'll come back and let me ask you this now while I have your attention. Did you feel a sense of reticence moving into the space? Do you have, well, you obviously have some type of well, let me ask you, what is your science background that brought you to patent law?
So I was a computer science engineer, so that went smoothly into cloud computing for patent law. You have to be a type of engineer or scientist to take the patent bar, for those that don't know. And then from there, I always knew I wanted to be an attorney, so I did not go into the workforce whatsoever. Looking back as a patent prosecutor, I'd say maybe spending 2 or 3 years as a software engineer might have been helpful in my early career. Now it doesn't matter. I keep up with science in different ways. But practice as an engineer before a lawyer is a consideration people should make if patent prosecution is what you want to do. And most patent prosecutors actually do usually practice as engineers first. But as technology changed, I found myself just becoming more interested in Bitcoin, even though I'm outside the fintech space. Bitcoin just is an interesting technology. So that got me involved in blockchain. And I actually went back to school for my LLM, focusing on IP policy in blockchain and machine learning models in 2018. And so that's where I kind of I thought I needed a little more education on where the law is changing there.
Absolutely. And I found myself pivoting around that time too. In the fall of 2017, I heard about this magic internet money or something, drugs, blah, 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 blah. I've since written a book, Digital Money Demystified, to challenge all of about 10 different myths that I believed, even just right sizing. Sometimes there's a kernel of truth, but to really push past to make sure that no matter personally what it meant for me, and I do own Bitcoin, I hold crypto as well, and I have since about 2018. But more importantly for me professionally was to understand a sufficient amount to make sure I was preparing the next wave of lawyers to be conversant in the space and to be ready and really to be ahead of the curve with respect to that. So thank you. Isabel, let's turn our attention to you. So go ahead and introduce yourself formally, and then I'll ask you a couple of the same questions.
Sure. Sounds good. So I am a counsel at WilmerHale's New York office. I focus my practice primarily on advising traditional financial institutions, fintechs, and crypto companies on a variety of regulatory compliance, enforcement, and licensing matters. Before Wilmer, I worked on similar matters at another law firm. And prior to that, I was actually a consultant at a Big Four professional services firm. So that was when I first encountered blockchain and crypto, and where I just became very intrigued by its promise, in among other things, to decentralize our financial system. And kind of having that, I was also in financial services in the advisory regulatory space when I was a consultant. So, kind of straddling the line between law, legal, and business, that was where I really thought, that blockchain and crypto brought a lot of promise, right, to really decentralize our financial system. And because of that personal interest, that was when I decided to really study the industry and kind of take on more opportunities, both when I was consultant, as well as now as a bank regulatory lawyer, right? Because that's really where my background is bank regulatory, consumer protection, and just really finding those opportunities to stretch myself and really I think, Tonya, to your point, right, find opportunities to assist crypto companies and blockchain companies with issues that traditional financial services institutions have been facing for many, many decades.
Absolutely, because when we think about financial technology or fintech, it's a wide array of different options. Obviously, and we'll talk more about cryptographically secure digital assets, but when we just think of the disruption of what are now seems to be kind of legacy companies like Leo Legacy. We have, Cash App, Venmo, the disintermediation when we think of the opportunities for Zelle, all still within a very centralized system. But you have to go back, of course, to PayPal, right? It was the new thing until now. I really see it as a kind of a legacy technology,
Absolutely.
right? Well, let's stay there. Did you have personally any hesitation as you were kind of straddling and learning a sufficient amount to make it relevant for your practice so that ultimately you could show up for your clients?
Yes, definitely. I mean, so I, unlike Alexis, I don't have a science or I don't have a technical background. So exactly. So I think even when I was first learning about blockchain, right, learning about crypto, I think I honestly, I mean, I'll say upfront that I got pretty lost. I think once we got to the really technical details,
Yeah.
but I mean, I think that, so I think there was definitely some hesitancy up front, right? Like, do I need to have that background in order to be a good like blockchain or crypto lawyer, right? To really give sound advice to my clients. And I think that I think it's definitely important to have that background, but I think that didn't really stop me, I guess, I was hesitant, but I think I was still so interested in the space that I was willing to learn more about it. And I think the more that I learned about it, the more I realized you don't actually need to have a science. Obviously, I think once you get to the really technical stuff, right, you have to defer to the experts. But you need to know enough for sure in order to know how to apply the facts to the law. But at least from my own personal perspective, that hasn't, I think, really stopped me from grasping kind of on a more general sense. And I think it really also comes down to the fact that my set of expertise, right, in bank regulatory, in consumer protection, that lends itself into this space in that I'm able to kind of bridge that gap, right, between the more traditional, I think, financial services lawyers versus the business people that are more focused, and the technical experts that are more focused on the tech piece, and really kind of, find my niche in that, being that connector. And I bridge the gap between the two spaces. And so there was definitely some hesitancy, but I think I was able to kind of overcome that.
I think we're in a space now where when I can think, I'm on the campus actually right now of Howard Law School. I have a talk here later today, but when I think about the way that I practiced after coming out of law school, it was always like legal was kind of the last to be consulted. The business folks, and then there was some technology, and then they would walk down the hall to get final approval. I think the best projects, and I'd like your thoughts on this before going back to you, Alexis. But Isabel, the talk about the idea of having a more collaborative approach, I think out of necessity to get legal involved sooner than later. It makes me, of course, think of the ICO or the the initial coin offering boom and bust when Ethereum really came into full view. And so many people unknowingly were creating the environment for unregistered securities, for example, right? And if they had consulted sooner than later, maybe they would have known. I think that the best projects are more collaborative from business, tech, and legal at the outset for blockchain and probably for AI and a lot of other Web3 technologies.
Absolutely, Tonya. I think, I think you hit the nail on the head. I think especially in traditional, right, TradFi, that is where legal compliance is consulted at the very end, right? Like it's really, and I think the point of legal is to be able to make the business's vision come true, with like trying to mitigate risk, but also to try to like work as hard as possible to try to make the business vision come true. I think that's still the case, at least in crypto space, with the crypto clients that I work with. But I think to your point, right, the ones that I think are successful are the ones that has legal and compliance kind of front and center. And part of that is because there's still so much uncertainty, or I guess actually a better word really is lack of clarity, right?
Right.
In the regulatory framework that governs this space. And because of that lack of clarity, I think it's even more important to kind of get legal involved as early as possible. I would say even as you're developing products, right? Because a lot of clients that we work with here at Wilmer are earlier stage, right, companies that are still in the design phase of their products, right? And that is when actually legal can really come in. And I think we can offer a lot of advice, and a very helpful advice in terms of shepherding a product to be as compliant as possible in this very uncertain, very unclear regulatory environment.
Absolutely. That reminds me, Alexis, of the time when there was so much going on at the end of the 20th century with respect to intellectual property. We saw the advent of Web 2.0. We saw the movement from kind of a Web 1.0 model where there was this dissemination of information from server to client, but it wasn't going the opposite way. Web 2, we have not only the exchange of information from client to server, but also from client to client, right, with peer-to-peer technologies. And it makes me think of Napster, Rockster, BitTorrent, all of those really important cases that laid the groundwork for a lot of the work that needs to be done now at the intersection of intellectual property and Web3 more broadly, but blockchain more specifically. So Alexis, how are blockchain technologies challenging current intellectual property law frameworks?
So we basically don't have those frameworks for Web3. If you think about blockchain as being the backbone of Web3, where we're having a completely decentralized web, we don't have the ability, and I mean this actually quite literally, to fully know the legal framework, because the decentralized nature of it makes it completely international, meaning every individual country's laws related to their, whether it's privacy law, patent law, financial law, whatever type of law it all intersects, and you need to be very aware of what's going on in other countries, know where your limitations are, know when to reach out for foreign counsel. But imagine having to reach out to foreign counsel for every little question to every little country. That's almost, I mean, impossible to do.
Right.
So our legal framework, at least in the US, is going to have to rapidly, which
we'll get to that. Right. We'll get to that.
But it rapidly kind of keep pace with the innovation of blockchain and similar technologies. Generative AI is a big one that's at issue right now as well, because otherwise it's just going to completely, the technology almost already is surpassing where the law can keep up. One example of that just outside of blockchain is copyright law with generative AI right now. In the past year, we've seen a boom of court cases in the US, and I predict in the next year to 2 years, we'll see a boom of patent cases related to Gen AI. It's a little behind copyright law. And honestly, they're small holdings in large courts because we don't know what the technology is doing yet and where it's going to go.
Yeah, this presents some really challenging issues that changes the framework, as you mentioned, in a really seismic way. When I think historically, and I love your take on this to drill down a bit further, we have all sorts of international treaties and conventions, but the primary laws were still geospecific. But with the advent of a more distributed, we're not there yet, but the technology, as you said, is and generally speaking, technology outpaces the law, but it's like by leaps and bounds at this point. Our system here in the United States in particular is just not set up. It's a feature, not a bug, that it moves slowly, not grinding to a halt, story for another day, but at least moving slowly and deliberatively. And when we think about the laws, the framework that is supposed to be enacted by Congress, for example, at the federal level, of course, but the implementation of that at the administrative level, the administrative morass seems to kind of muck up the works, even though it is the administrative state that is supposed to be in the best position as a matter of subject matter experts in order to navigate it. Which I know kind of is a mouthful. Have you had any experience? Do you have any thoughts about the challenges of getting the necessary framework to match what the needs are from an intellectual property point of view?
Interesting question. So actually back in 2018, when I did my LLM, I was in Washington State, and Washington State was interested in looking into blockchain and how it could be used for things like recording marriage licenses, recording driver's licenses. And then also on, so I actually worked with a group that spoke with the state legislature on that. And they just wanted to kind of know, what is this? Because at least in 2018, when I spoke with most people, if I said blockchain, people said Bitcoin, and I said no, no, but yes, right? So we're talking about the framework, and I think people need to understand that blockchain can be used for so many things across the world, little to big. One of the other interesting areas that I worked in was supply chain management. And so thinking about just how the technology can be used, and then what laws that's going to affect. So in addition, the Washington state government was worried about how the UCC applied, specifically Section 9, talking about what does it mean to be recorded. And so I did a bunch of research back then, papers on what does it mean to be a record, if this is technically an immutable record. So yes, it should be a record. Does it fall under the UCC definition of record? And you could argue, as lawyers always do, either way. And I'm not a UCC lawyer. That was just something we were asked to do. And it's interesting to think of all of the different areas of law where something as simple as the definition of a record or the definition of an assignment is going to have to take into consideration how the technology is moving forward quickly.
Absolutely. That's such a great example. It reminds me a lot of the work that Caitlin Long did in Wyoming around that UCC. I'm not a UCC lawyer either, but the idea, and for those who are trying to understand, well, what is a blockchain, we really are talking about a digital record of transactions and balances for, in the case of cryptocurrencies, a particular asset, whatever their native asset is, and also other tokens that may not be a native digital asset, but records its transactions to a specific blockchain. So for example, with Ethereum, the native coin is ETH or Ether, right? But there are thousands and thousands of tokens based on an Ethereum standard that can write their transactional balances or data to the Ethereum virtual machine. So, and that's kind of a story for another day, but if you don't understand any of those things, if you've ever been, this is very rudimentary, I'm sorry, that's going to hurt the heads of technologists, but a group text and you have 10 people talking, you delete that record from your phone, but 9 other people still have it. And then you kind of extrapolate that out to millions of computers around the world. You start to understand the redundancy of information and therefore the security of that information. And so that can be used for records, as you said, supply chain, so many other areas. Public records was always fascinating to me. I think we'll see more in terms of identity, so many other issues. Isabel, I'm coming to you, but because I just want to close out this one point with Alexis, talk finally about for this particular topic, the role that patent protection plays in protecting the ecosystem as it grows. This was one of the things that was most exciting to me early on, reading a paper about the nature of open source software for layer 1 protocols and, the majesty of Satoshi, whoever he, she, or they are, that could have patented, right? You take technologies that existed, but combine them in a novel way, chose not to. Understandably, but what happens when you have bad actors that might want to take over the technology? So putting a point on the question, the role that patent pools might have in protecting the development of the technology.
So that is a large question. To make it a little one, So we are lucky that Satoshi didn't patent blockchain, because otherwise, well, I mean, at this point it would be almost 20 years. So it
True,
would
fair.
but the innovation that's happened on top of blockchain in the past 15 years is vast. So the fact that it's not patent allowed all this open source material to come out, allowed people to keep building on it. Now companies are patenting smaller inventions on top of blockchain infrastructure, which allows for many companies to have their foot in the door and also be allowed to patent larger portions of frameworks as they innovate more on top of what's already existing. So while blockchain as an idea exists, the idea that the idea that it'll ever be completely restricted by a patent is at least safe from our laws. Patent pools will be an interesting, as we see companies come together with each little bit having, I have this part, I have a patent in this, I have a patent in Y, I have a patent in Z, let's come together and block this area out. I think we'll be facing new challenges when that comes out, because a lot of what technology is coming out of is startups right now. So when patent pools get together, they're going to be blocking out those small innovators, but those small innovators get purchased by Google and Meta and all of those big companies for billions of dollars, and in a lot of cases. So if you knock out the smaller startup companies that have been booming over the past 10 years, that will be difficult to see technology-wise. However, I also have a hard time believing that kind of the startup world would allow this to happen. So even though they don't have that regulatory in as much as big companies do, I don't see it being a huge problem as long as we keep moving in the way we're going. The bigger problem I see is people, and this might be a later question, is in the patent system since 2013, the United States has moved to a first to file system. So filing your invention first before anyone else, even if it's by hours, is very important. So when these startups are building their company or building their innovations, they might not be thinking about patent law. Going back to what you were saying about the lawyer is not consulted until the end. The patent lawyer needs to be consulted in the beginning and say, okay, you have enough information for a patent. We need to get this done. And that's an expensive process, a lengthy process, and a process that most engineers do not care about.
At all. Absolutely. And it makes me think of so many of those early projects, and probably still today. I'm a little more removed from the projects of today, but it made me think of so many white papers up that describe the technical white papers that described with specificity, so much so, and they could be up for over a year or whatever the time period is. And even if they had the idea, and a year and a half later go to a lawyer, they've blocked themselves out. So that's a really important point. Isabel, all right, now let's get into this regulatory landscape, shall we? The first thing I would love to hear your reflections on is kind of the lead up to the albeit begrudging, my words, not Isabel's, from the SEC and from Chair Gensler to begrudgingly approve the 10 new ETFs and the one conversion for Grayscale GBTC. As a matter of full disclosure, I am on the board of Digital Currency Group, and DCG owns Grayscale. So I'll say less about that, but to get your opinion on just kind of the ramp up to where we are now, with 11 products that are approved by the SEC to trade as a spot Bitcoin ETF.
Absolutely. and I'll say a little bit, and the regulatory framework, as I think we talked a little bit about earlier, is so complex. So I'll just kind of lay the groundwork for just what are the players that we're talking about, and then talk about how I think it's really changed in the past, honestly, just really 6 months, right, to a year. So I think, as you already mentioned, Tonya, there are so many players in the regulatory framework, in the regulatory space, that have tried to extend their regulatory enforcement authority over this space, right? So I think we already know, right? I think, I guess to take a step back, right? The regulatory framework for blockchain or for digital assets is driven by two things. One is the status of a particular asset, and one is institution involved, right? So when we talk about status or classification of a particular asset, we're really talking about whether or not the particular digital asset can be classified as a security. And that we'll have to look to, obviously, the SEC that has authority over the securities market, including digital assets and our digital asset securities. Non-security digital assets are commodities, and that's where the CFTC comes in, right? CFTC has authority. It's the primary regulator over the U.S. derivatives market. And derivatives market includes, of course, commodity futures, options, and swaps. While CFTC does not have regulatory authority over cash commodity, it does have very broad anti-fraud and anti-manipulation enforcement authority over cash commodities. And the CFTC has previously determined that digital assets are commodities under the Commodity Exchange Act. So we already talked about the SEC, CFTC that primarily offer, right, investor protection. That's what they focus on. But aside from that, we also have to talk about a few other players that actually have, I think these are a couple of players that are talked about maybe a little bit less in the public arena, but they actually have a lot of authority, and their authority actually spans a wider range of industry, digital asset industry participants. And those are essentially two of the bureaus of the Treasury Department. They are, one is the Financial Crimes Enforcement Network, which stands for FinCEN, probably a term that folks have heard about a little bit more. And the other one is Office of Foreign Assets Control, which is OFAC. Right. So FinCEN is a bureau within the Department of Treasury that administers and enforces the anti-money laundering, the AML framework under the Bank Secrecy Act. And financial institutions under the BSA include money services businesses, which include money transmitters, which actually apply to, I think, the vast majority of digital asset exchanges, custodians that you see that are active in the market right now. And OFAC is another bureau also within the Department of Treasury that administers and enforces economic and trade sanctions based on U.S. foreign policy and national security goals. So OFAC sanctions applies very, very broadly. I'm not an OFAC expert, but I know that it applies very broadly to all U.S. persons, and also some persons that are not maybe classified as U.S. persons, but that could still be, that are operating outside of the United States could still be brought within the remit if they actually work with U.S. companies. So SEC, CFTC, FinCEN, OFAC, as if that's not enough. We also have our federal bank regulators, right? That's, where really my expertise comes in, where we have our Fed, the Federal Reserve, we have our OCC, Office of the Controller of the Agency, and we have FDIC, of course, that insures all of our deposits. And we have also state supervision, right? So we have our New York DFS being kind of the state financial regulator of New York, and every state within the United States also have their state financial regulators. So some of these states, such as New York, have also released rules to regulate industry participants in this space. So we have SEC, CFTC, FinCEN, OFAC, federal banking regulators, and also our state banking or state financial regulators. And all of them play some role in this space. And Tonya, I think so with all of that kind of setting the stage, kind of going back to your earlier question about how that's changed, right? So obviously, I think it very, very big news, right, recently with the approval by the SEC. Again, so my focus is more on the bank regulatory space, but from what I understand, right, Gensler has previously been very reluctant, right, to actually approve, obviously, Bitcoin spot ETF. But I believe he was, as I understand it, forced, essentially, right? I mean, really
Right. Yeah,
forced
by the federal courts. Yeah, yeah.
by federal courts to make this decision. And part of that is because the SEC previously, I think, approved the futures ETF,
That's correct.
right? And obviously, I think the court, essentially the court determined that, there's no reason for you to have previously approved the futures ETF and now, like finding reasons essentially to not approve the spot Bitcoin ETF.
Right.
So I think that's obviously very big news, but I think what I would say, if there's anything, there's a takeaway, is that the SEC has been, I think, one of the most aggressive regulators in this space, right? Chairman Gensler has basically, whereas I think previously that we have Jay Clayton, which was had previously said that, Bitcoin, Ether, right, which is the native coin of Ethereum, should not be considered securities. I think more recently, what I've heard Gensler say is that he's even walked back essentially on the classification of Ether.
Right.
Instead, everything else aside from Bitcoin, has the potential to be classified as a security and to be brought within the regulatory remit of SEC, which would be a huge change, right? Because that would mean that the SEC would have registration. I think there would maybe need to be registration requirements, supervisory examination, and a number of other regulatory requirements, disclosure requirements, investor protection requirements, that would apply to all of these market participants. So while I think it's certainly it's a step in the positive direction, I don't think we should, again, not speaking as a securities attorney myself, but I don't think we should look at that as necessarily, like the SEC kind of loosening its grip, I think, on the—
Absolutely. And perhaps we'll even try to double down. There's so much conversation about whether or not we'll see a spot ETH ETF by year's end, maybe even by July. And it has been interesting to watch. This was kind of like the administrative law nerd in me, seeing the interplay of the morass, that kind of the alphabet soup that you describe within administrations and independent agencies and the cabinet level, of course. But also you see on the legislative side with legislative inaction, the enabling legislation is what it is. And the question before the federal court was whether or not Gensler's actions or refusals were arbitrary and capricious, given the fact that we had the futures Bitcoin ETFs, but not the underlying asset to trade on the spot price of Bitcoin, and really forcing his hand to do so. I testified before the House Financial Services Subcommittee on digital assets, financial technology, and inclusion last year. And there was this discussion around enforcement, regulation by enforcement, right? Kind of looking like choke point 2.0, choke point 1.0 under the Obama administration was an official policy that had to be rolled back because of the courts. So now it's not really on the books, but it seems like, and you come from the prudential regulatory environment, is there a negative impact on the ability to kind of onboard and offboard through traditional banking products, right? That keeps crypto companies outside. It was difficult for them to get banking, bank accounts, difficult for them to transact. Any thoughts about this idea, at least from the prudential side of regulation, on kind of this choke point idea that is having a deleterious impact on startups being able to really innovate in the space, and ultimately what that means for our leadership as Americans to even move forward?
Absolutely. So that's an interesting question. So I think from a prudential regulatory perspective, right, I think our federal banking regulators, right, OCC, Fed, FDIC, have been very wary. I think for good reason.
Absolutely.
Of a lot of the traditional financial services, financial institutions that have I guess, considered, perhaps dipping their toes in the digital asset space, right? There have been, I think, both OCC and the Fed have released essentially not formal, right, but informal guidance that basically say you need to think very carefully. This is a very risky space, and there are a lot of consumer protection issues involved, right? And two of the regulators that I failed to mention previously when I was running through my alphabet soup,
it's easy to do.
As if there hasn't been as if there isn't enough, right? There's also the CFPB, right? The Consumer Financial Protection Bureau, and the FTC, the Federal Trade Commission. These are primarily, whereas the SEC and the CFTC are maybe more focused on investor protection. CFPB and the FTC focus on consumer protection, right? And they primarily administer a set of laws that prohibit unfair, deceptive, or abusive acts or practices, right? UDAP or UDAP.
Right.
Law. So both from both the prudential banking regulators and also CFPB, FTC are very, very focused on consumer protection, right? If you think about kind of the traditional banking institutions and financial institutions and the type of users that they have, right? I mean, that is the most, I think, the scale is vastly different, I think, from the still like the Main Street, I guess, the Main Street or the Main Street audience still quite different, I think, from the folks that invest in necessarily digital assets, Bitcoin, Ether, and especially the ones that actually invest in altcoins, right? So I think for very good reason to bring it back, federal prudential regulators have been very wary of the space. Part of the reason why they've even been they've been cautioning their existing, banking regulation, their existing financial institutions that are already subject to their supervision and regulation, cautioning them against kind of entering into this space. And furthermore, I think that's part of the reason, I think, when it comes to startups, right? Very, very few startups would be applying for a license, for example, with the OCC or the Fed or the CFPB. But I think there have been some, with that said, I think going back to what I said before, state banking regulators have been a little bit more, for example, the New York DFS has a licensing scheme called the BIT license, where essentially a lot of startups have actually applied for a license as a trust company, through a state banking regulator. So they'd be regulated at the state level rather than at the federal level. But it's at the state level, they would be subject to actually a lot of the same rules as a bank would be if they were regulated by, let's say, the OCC as a national bank.
That's really, really important point. Thank you so much for that. It was great and very nuanced. Let's switch our focus back to intellectual property. And Alexis, talk to me about patent prosecution and portfolio strategy in emerging technologies. We started to touch on it a bit in the last part of our conversation. Let's drill down a little bit more and talking about strategies for obtaining intellectual property assets and blockchain, AI, ML. Actually, that's big enough to let's start there.
Sure. So as you said earlier, we're really standing at the cusp of technology in these technologies, like almost this year, 2023, beginning of 2023 is where we saw this kind of technological boom in generative AI, machine learning, and those things build on top of blockchain in a lot of senses, in a lot of cases. So it's imperative that we understand as patent prosecutors, in general, a patent doesn't actually become public information for usually about 18 months. And even then, you can keep your patent private until it's granted. So right now, if you think about people that probably filed patents in the beginning of 2023, we still aren't seeing those patents published yet. And so as a patent prosecutor, one of the things I'm looking forward to is seeing a boom of patent publications. Well, there's still applications come out and see what's out there in this landscape of patents, because to even know where it is that you can practice, like in the field, the freedom to operate concept, you have to know what's available. And right now, we don't even know what's available, what's been patented. Once something's patented, we know, but right now we're seeing small innovations in being patented. It'll be interesting when larger patents come out, and then the court cases that, luckily I'm not a litigator, court cases that follow in the years to come from those. And so the biggest strategy point I would say to get across to anyone, young, old, small, individual, large company, is file soon and file often. Even if you're just filing a provisional patent, which gives you a 12-month waiting period to file a non-provisional, which is what you would eventually fight with the United States Patent and Trademark Office to get your patent granted. Provisional patents can be done relatively cheaply in the scheme of patent law. And it saves your place in time, basically, because first to file system means one day can ruin your company. And so it's very important from a strategic point to make sure that even if you're a small innovator, you're considering what you can do to protect yourself. And one of the interesting things the PTO, the Patent and Trademark Office, does is individual innovators, they'll work with you because they know hiring a patent attorney isn't expensive. It's obviously not going to be the same as working with a patent prosecutor, but individual inventors can get a lot of private or public help from the patent office to try and file things like provisional applications. I am not recommending that as a patent prosecutor because patent law is so innovative. You want to make sure you get the right things filed. However, if money is what's standing in your way, then it is an option to go to the PTO and see what the availability they have to kind of let you file that provisional application. Non-provisional is where you need that patent prosecutor for, because especially when it comes to all of these cutting edge field technologies, we are, patent law comes down to patent claims. And if you have a patent claim, it's effectively reading a different language. And then, as you say, the language in blockchain and the language in machine learning, it's all technology language. So we now have this combination of technical language meeting patent language that is so nuanced and doesn't have clear definitions lined up across even, I mean, our own country, let alone the world, that you have to be very careful. One has to be very careful as a patent prosecutor as to what language you're using in your patent applications. And in the past year, since Gen AI became public and changing every single day, we as a firm have been keeping up with evolving language in a way that we have, but before it was something's changed, a court case comes up, you no longer can say XYZ in a patent. That happens every few years is what we're used to. Right now, not because of court cases, but because of the change in technology, we're seeing those amongst the firm, people saying, actually don't use these words, use these words. And it's very nuanced, so I don't want to get into just random language. It's interesting to hear other attorneys say, what, this has changed in the past month. People are using this differently now. So when you're writing your patent, think about that differently.
That's really fascinating. I had a talk yesterday, and we were talking about even the evolution of the way that we are describing cryptographically secured assets. We all talked about, cryptocurrencies, a bit of a misnomer, particularly because in this country, crypto is taxed as property, or classified, I should say, as property. And so it has these really interesting programmable attributes that isn't a neat fit. And also, I think it's misleading to simply say cryptocurrency when we have, as a matter of tax, people, in addition to income if you're receiving it, but tax on the gains, capital gains, right? In the same way as stocks. And so thinking more broadly of digital assets that leverage cryptography, which just is a type of encryption for purposes of messaging, right? And that is really, really important about staying on top. It goes back to my original point as a matter of ethics, of technological competence, keeping up with the language that will be relevant and giving your clients, and as you are stating claims, the best chance for success, right? So it's taking the expertise of drafting claims, but also using the language that comports with the state of the art, quite frankly. Talk to me a bit about on the copyright and trademark side. It makes me think of exploitation of all intellectual property assets, but we have unique issues around licensing in the digital age with copyright and trademark. Interested in your thoughts there.
So with blockchain in particular, it's going to make copyright law very interesting in the United States, because in order to know whether or not something is infringed on the blockchain, it is there, it is immutable. We will know. And so if copyright law or if copyright registration was completely put onto blockchain, and we also had you can use smart contracts, which are again built upon blockchain for licensing purposes. Now that's asking a great deal, and I'm not sure that's all going to happen.
I love it. I have the benefit of being an egghead a professor, so I can talk normatively. You're speaking practically. I wrote a whole paper that may never come to fruition that is titled CryptoKitties, Cryptography and Copyright. And that was one of my arguments that to leverage this for a number of different public records. I don't know if we'll see that come into fruition, but continue, because you at least have my attention.
Yeah, and I enjoy that. It's kind of thought experiment like at this point. But from that concept, from the thought experiment concept, we would be able to court cases on copyright infringement would be much quicker, much less expensive, because everything would be on the blockchain. It's public record. People would be able to view it. It would just make everything much more simple. And in terms of public documents, driver's licenses, marriage licenses, death records, birth records, I actually had to get birth records for my great-grandparents from Italy, and that ended up not working out well because the church burned down. There's no such thing of that when it comes to a blockchain, unless we reach, catastrophic levels of computing.
And then we have other problems, right?
Right, we're past that. So having important documents like these, including copyright registration, trademark registration on a blockchain infrastructure, would allow technology to move forward very quickly, and allow, I think, individuals that don't necessarily, whether they understand the law or not, be able to more easily reach the law they need to look into for whatever problem it is they're having. It also would prevent a lot of infringement issues, just in terms of the actual stealing of the product, not in terms of going to court or litigation purposes, but you can block people from getting access to things more easily using these technologies. And so by having greater spread and greater use of these in practice, it will improve technology for everyone. From the regulatory, legal, federal standpoint, the law standpoint, the law is chasing technology, as you said, and it's one of the issues that the Gen AI laws that will be coming out, I don't know what they will be, but they will be coming out. I was originally worried about was the same thing that happened years ago with stem cell research. By putting restrictions on how stem cell research could be used, there were, a disruption in the medical field. However, and a year ago, I started thinking about this, if we put restrictions on what generative AI can be used and how it can be used, there's going to be a huge kind of break in how we're moving forward so quickly in this technological age. However, so much has happened in the past year technologically that there's no going back.
Right.
From a copyright perspective, we're going to be seeing a lot of cases on what data was used in data training sets to train these large language models. And you have to assume that copyrighted data was used.
Right.
But we've now had hundreds of, probably thousands of models by different companies, by different individuals created off those original models, that there's no going back to figuring out what training data was used, what was copyrighted, and how it was going to be fixed in the future, how that copyright infringement is going to be fixed. And so a lot of what I'm seeing, I'm sure a lot of what you're seeing on the fintech side as well, is keep up with the law, keep up with the technology, because every case is going to be important. And we're all waiting for that next big case to happen, or the next big regulation to happen.
Yeah, this is not very often in one's career that you get to witness building the plane while we're flying it. And that's certainly how I feel darn near every day. I hate to stay away from crypto Twitter too long, because I'm sure something has happened since we've been here in this less than 1 hour. I see that we have about 5 minutes left. And so I'm going to toss this back to you, Isabel, for some final thoughts about future developments in law and policy, any predictions, things that might keep you up at night as you are working your way through your practice on the regulatory side. What are some things that we can let our viewers know today to look out for that is on the horizon?
Yes, sure thing. I think one of the things that I've been thinking a lot about, just I guess late at night when late at night on my bed, is I think ultimately the way we should think about how I think there's a lot of pushback from the industry in terms of applying existing law, right? Whether it be securities law, right, derivatives, CFTC, or consumer protection law or prudential law on on digital assets is as such. There are things that just don't apply neatly, right? There are certain disclosure rules, right? There are certain consumer protection or investor protection rules, registration rules that just don't apply neatly, right? On this on these products, right? On the services that are being offered in the digital asset space. But I think one of the things that I always think about, or I have been thinking a lot about, is what makes, I guess, cryptocurrency different, right, from fiat currency, because I think it's those differences that are going to have ramifications in terms of why the regulators continue to feel the need to want to apply limitations, restrictions, and all of that on this industry. And, I think on one end, if we think about it, right, I think blockchain or cryptocurrency, there's really less actually consumer protection risk, or less in the sense that transactions are permanently recorded. I think both of you have touched on this point. Transactions on the blockchain are permanently recorded, right, on a public ledger. And, that because of that, that would allow really analytics tools to have really greater monitoring and analysis than is actually typically available for traditional fiat currency or fiat transactions, right? So that's, I think, what actually reduces the risk, right? I think in comparison to fiat currency. But there are also certain aspects I think the regulators are very, very concerned about that I still haven't figured out a good way to really, and maybe I think nobody has been able to really figure out the right way to approach, which is pseudonymity, right? The fact that, wallets are not linked in any indelible fashion to a real person's identity. And that is where, the two agencies I talked about, FinCEN and OFAC, really come in, right? When it comes to illicit finance or like money laundering risks, right? When you have the anonymity, right, with associated with transactions, and also global reach, right? Cryptocurrency can be used to conduct transactions globally, crossing international borders, virtually without any restrictions, right? Whereas in traditional finance, you have all of these intermediaries, right, that are verifying customers' personal identities. You don't have that with blockchain, right? Disintermediation, which Tom mentioned several times earlier, which is that where individuals do not need to utilize a regulated intermediary to conduct transactions, right? And then finally, the near real-time irrevocable settlement, right? Where transactions on distributed ledgers are validated quickly and are irreversible, right? Cannot be reversed. So all of these things taken together, I think, are just things that we have to work out. I think that, these are really the reasons why the regulators are, like all of these regulators, right, are trying to come in and regulate different pieces of the industry. Right. And I think that's just something that I continue to think about, that I think all of us should keep in mind when we're dealing with regulators, is how do we assuage their concern, right? And how do we really differentiate like our product from what, maybe some of the other products out there right now that are causing them headache. From a consumer protection and privacy perspective.
Absolutely. And I think that as the ecosystem and the technology, the user interface, the user experience continues to mature, those things will be ferreted out in a way that people can really see, less than 1% of the technology, less than 1% of the uses fall in the criminal lane. Now, when they fall, they hurt. But it's one of those myths I talk about in Digital Money Demystified, to leave at least right size. I think it's a terrible place for money laundering when you have this permanent immutable ledger where you can start to put the pieces together. And in my class, in the last couple of weeks, we've been covering blockchain forensics, and it's really fascinating to see. It's the reason that you can bring someone to task like a Sam Bankman-Fried within a year with a Ponzi scheme, where you compare it to a Bernie Madoff, where it took years and years and years because of fiat. Story for another day. All right, Alexis, what do you what keeps you up at night at the intersection of intellectual property and blockchain and crypto technologies?
As I said before, I was worried for a little while that the law would come down and say, these things aren't going to be patentable. We'll get an Alice type case where it says,
Right.
software is now on this precipice of maybe not being patentable, but they've been saying that for too long now, and it's past that point. So at first I was worried that that's what they were going to say, especially about generative artificial intelligence. But realistically, we've come too far technology-wise for the law to, in my mind, to really quash anything that I could be worried about from a patent perspective. However, I'm on the edge of my seat, kind of waiting for it, like waiting for that next, especially the first patent case. Like, we've seen the copyright cases, and those are interesting, but obviously as a patent prosecutor,
Right.
I'm waiting to see that first patent case on a Gen AI product. And the biggest issue we're facing right now is inventorship, and how much. So an inventor has to be a human. And for how long that's going to stay true will be interesting, because eventually, we're not there now, but eventually we could get to a point where a lot of these generative AI models are creating their own inventions. That is not too hypothetically far away. So inventorship for patents is going to be an interesting thing to keep in mind as that keeps changing. But also, even right now, how human inventors are using Gen AI, that is becoming a problem, and that kind of keeps me up at night. But I see Charlie's back, so I think our time is up.
Thank you so much to Alexis and Isabel. Charlie, we hand it back to you. And final thing, if all of this was gibberish to you, but you stayed until the end and you still want to separate fact from fiction to get you a head start, I recommend Digital Money Demystified. It walks you through so that you can make more informed choices for yourself personally, but more importantly, professionally for your clients. Charlie, thank you very much, sir.